Дорогие друзья, добрый день. Рад приветствовать вас на втором международном юридическом форуме, как его организатор. Я очень рад приветствовать вас на...
I'm very happy to welcome you at our roundtable and at the second International St. Petersburg Legal Forum. And I'm the co-moderator of this roundtable. I found out that as soon as I appear at a certain round table, people start leaving the round table. We are not so numerous today, but I think that this discussion will be very fruitful and interesting, because here, in such a closed community, we can be honest, frank, and up to the point. So that's why, first of all, I would like to introduce my co-moderator. For the organizers of the forum, it's a great honor to have Mr. Hans-Jürgen Hellwig, a partner of a leading German firm, Henkel Müller. So the floor is yours.
Thank you, Mr. Lyubimov, for the kind introduction. If I may take the lead, I would first of all invite Mr. Akira Kawamura, who is the president of the International Bar Organization and who is in a way the father of this session. I would like him to introduce the participants of the panel. Akira, please.
Thank you very much. Let me introduce our IBA team on this issue. We have been working on the cross-border legal service program for many years. Since 1998, when we had a big global conference on this issue in Paris. We call it Paris Forum. And at the Paris Forum, we all agreed to manage this question as the not just a trade problem, but the legal professions problem. It was important time. We all recognized that the issue is not just a domestic legal system, but that is a problem of global legal profession. Since then, all of us have been working very hard on the, this issue on the global basis. Let me introduce member of IBA's Cross-Border Legal Service Committee. Hans-Jürgen Hellwig is the leader of this issue from the beginning, and he is now chairman of Cross-Border Legal Service Commission of IBA. And Ben Greer, he is sitting far beyond, but he was the Secretary General of IBA when IBA took up this question, and since then he was very actively coordinating with the World Trade Organization on this issue. So he was, well, in a sense, promoter to open up the domestic markets for the global lawyers. And Alison Fook, she is at that time a manager of international section of Law Society of England Wales. And she has been working on this very hard. And I understand she is still consult on this issue to the law firms and bar associations. She is a kind of think tank of this issue, and she is very rare, one or two knowledgeable person in the world. And Muranov, Alexander Muranov, he came to here a bit late, but she was the new rising sun and star of hope in the IBA, and I'm very sure he's now a very active member of a cross-border legal service commission of IBA. I'm very sure he will be the leader of the next generation of the IBA. He is also very knowledgeable. And I am not sure if I am in the position to introduce other two extremely distinguished speakers. But let me introduce Mr. Gu Jie. My pronunciation was correct. I'm sorry if I was wrong. Ji Gue. Oh, sorry, yes. Mr. Kan Yu, Deputy Director General of Ministry of Justice, People's Republic of China. I'm terribly sorry for my mistake. Okay. Oh, I see. Let me introduce her. And Miss Taek Jiu?
Kill.
Kiltaek, okay. Kiltaek. He's a Vice Minister of the Ministry of Justice, Korea. And as you may know, Korea is now trying to internationalize, changing the legal service system, opening up the market and trying to be the cross-border global legal profession, center of the global legal profession. Formidable power in the world market nowadays. So it is very interesting to listen to his views about this question. Thank you very much, Mr. William.
Right. I'd like to thank Mr. Kawamura, who would definitely be a better moderator than I am, and who's really not only founder of this roundtable, but who is also one of our best friends in issues concerning the forum in itself. Я уже забыл, что я говорю на неродном языке. Вот.
And Mr. Kawamura was amongst the first stars of the legal profession who supported our forum, and a special thank you goes to him for that. And thanks to our partnership with the International Bar Association this year, we've been able to carry out a number of joint events as part of this forum, and our roundtable discussion is amongst such events.
Inquire whether there are time restraints for some of the panelists, so that they cannot stay until the end, because I would then invite those panelists to give their presentation first. Can you stay until the end? Yeah? And Mr. Yu? Can you stay until the end? Okay, perfect. Excellent. I think that's a good sign. It demonstrates the interest that everyone has in this session. Let me start to introduce the topic to you by, first of all, paying tribute to this wonderful and beautiful city of St. Petersburg. A city that is so much linked with the history of my own country, Germany, and of the other countries of the Middle and Western Europe. I have traveled a lot, but I've hardly ever seen a city which has such an harmonious and homogeneous layout and house and palace lines to the right and to the left side of the streets and avenue. Hardly ever seen a city as beautiful as St. Petersburg. Most of that goes back to Catherine II, Catherine the Great, who was really bringing St. Petersburg to the height that we admire today. What was the world like at that time, some 230 or 240 years ago? She reigned from 1762 until 1796. What was the world like? There was already at that time a good amount of cross-border activities. There were many Middle and Western European princesses, beautiful princesses that married equally beautiful Russian princes. Or in terms of those days, they were married by the Russian princes. And they moved to St. Petersburg. In today's terminology, freedom of persons. Catherine the Great purchased lots of art from all over Europe and thereby laid the foundation for the beautiful collections of the Hermitage. In today's terminology, that was freedom of goods, freedom of trade. Catherine II retained architects like Mr. Frastrelli from Italy and garden architects from France like Monsieur Leblanc to design the layout, to design the houses and palaces, to design the gardens, and to supervise their construction. That was freedom of service in today's terminology. Now, freedom of legal service was not an issue at that time. So, if we had been around, all of us in the room, some 230 or 240 years ago, if we had lived already at that time, we would not be here in St. Petersburg today, because our topic of today was not a topic in those days. But it is a very relevant topic of today. Cross-border legal services. What is a lawyer? A lawyer has a double function. He is an instrument of justice, and he provides service to the client by assisting the client in legal transactions and by representing him in the courtroom. And by rendering this service to the client, he fulfills his function as an instrument of justice. So these two are not a contradiction. They are two different sides of the same coin. A lawyer can achieve these functions only under certain conditions, if certain conditions are ensured. He must be independent from the authorities, and that independence must be ensured. He must not be in a situation of conflicts of interest, and he must treat confidential and secret what the client tells him. Looking back into history again, one finds that all the countries have their different culture for the legal profession. The legal profession in each country has different roots, and still there are some commonalities. These differences explain why there are difficulties when lawyers do cross-border work. They come from one cultural background and they render service into another cultural background. And the issue of our today's session, the issue of that is to deal with these situations and to find an answer to the question, how can regulators, in particular in the host country, the country of destination, deal with such situation? That is the background of our topic. Now, may I suggest that we start by looking at this issue, by starting with countries a bit further away, i.e., let us not start with a European focus. Let us start with a focus stretching out a bit further. And I would like to invite, first of all, if I may, our panelist from Korea, Vice Minister Gil Tae-ki, to take the floor and present the Korean experience on the topic. The floor is yours, please.
Thank you, moderator. Distinguished guests, ladies and gentlemen, I am the Vice Minister of Justice of the Republic of Korea, Gil Tae-ki. First of all, I would like to extend my appreciation to the organizing committee and the moderator, His Excellency Deputy Minister of Justice, Mr. Yuli Lyubimov, and Hans Wilgen Helbig, for giving me the privilege to speak at this prestigious roundtable discussion. Please allow me to elaborate my views on the topic of this table's discussion. Legal services market liberalization is an important issue related to cross-border legal services practice. Because how and to what extent the market should be opened up great affects the international legal services practice. Therefore, I believe that examining the relevant policies of the states, especially that of Korea, would provide good insight for this discussion. One merit of legal services market liberalization is that consumers can access high-quality legal services with convenience. It would also enhance the competency of domestic law firms as they may adopt the advanced legal advisory skills of the leading law firms around the globe. The government should strive to maximize the advantages of the liberalization by taking the following measures. First, the scope of the opening should expand over time to allow consumers to receive high-quality legal services. The scope may not be broad at the initial stage of liberalization, but it should be gradually expanded. This will allow various and specialized foreign law firms to enter into the domestic market and enable them to compete or cooperate with the domestic law firms in constructive ways. In case of Korea, the liberalization is a gradual process. The market opens up in 3 stages over a 5-year period. The initial stage allows foreign lawyers to provide advisory services on foreign laws and on certain areas of international law. In the second stage, foreign law firms and Korean law firms are permitted to work together on a case-by-case basis. In the third and final stage, foreign law firms may establish a joint firm with Korean law firms, which will be permitted to employ domestic lawyers. By the third stage, the Korean legal services market will be close to being full opened. Therefore, I anticipate that the foreign law firms will be able to compete more freely. Second, a thorough verification mechanism should be in place to attract excellent foreign law firms to the domestic market. Foreign lawyers seeking to work in Korea are required to undergo a legal qualification approval procedure. In the process, we verify whether foreign lawyers have the expertise on the laws of their respective countries. As the foreign law firms approved by this process will be recognized for their expertise and excellencies, I believe that they will gain the consumer's trust without much difficulty. In addition, their high-level advisory services and law practice management skills are expected to strengthen the global competitiveness of our domestic law firms. Third, there should be an institutional mechanism to provide accurate and reliable services to consumers. To the end, the lawyers need to provide legal services close to consumers on a constant basis. The foreign lawyers are obliged to establish and maintain an office in Korea in order to practice domestically. In addition, to ensure their commitment to the domestic practice, they have to remain in Korea for at least 180 days in a year, starting from their first day of practice. For the foreign law firms entering into Korea, they will be able to provide local services like the domestic firms. This is expected to greatly improve consumer satisfaction. However, legal services market liberalization could also have some negative side effects. Consumers might suffer from underqualified foreign lawyers. Foreign lawyers might violate or evade domestic laws and regulations. To prevent this, initially there should be a redress mechanism to protect consumers from malpractice by foreign lawyers. The partners of foreign firms' Korea office are required to subscribe to an insurance plan which allows the consumers to seek redress efficiently. Moreover, the foreign lawyers' illegal acts and malpractice which disturb the legal services market should be strictly regulated. In case of an unlawful act, the foreign lawyers may be subject to criminal charges in Korea. Furthermore, legal malpractice may be subject to disciplinary action. To summarize, the essence of legal services market liberalization is to ensure that the consumers are provided with high-quality legal services at a reasonable cost and to improve the global competitiveness of domestic legal services. To do so, institutional support and adequate regulations are needed, which will enable both domestic and foreign lawyers to build their expertise, as well as develop their respective legal practice skills through competition. I am convinced that fair and balanced competition and cooperation between domestic and foreign legal professionals would result in the most desirable form of legal services market liberalization. Thank you very much.
Thank you, Mr. Tekigil, for what I think was an excellent overview, because you not only have given the situation in your country, but you have also touched already upon all the relevant aspects that come to bear in the discussion of cross-border regulation. Can I now invite Mr. Kang Yu from Beijing, please, to give the Chinese view? The floor is yours.
非常感谢。Слушайте.
I will tell you about the situation in China. First of all, I would like to thank the organizing committee for the possibility to participate in this round table, and also to thank our colleague from the Republic of Korea for a very interesting presentation, as well as all the participants. And I'm also very grateful to the Ministry of Justice of the Russian Federation that provided us with the possibility to visit this wonderful city of St. Petersburg and participate in this very important event, the Second International Legal Forum. For multinational cooperation, this forum is of great importance. Last year, the Minister of Justice visited Beijing, and this visit was very fruitful. He met the Minister of Justice of the People's Republic of China, so that's why we are paying a great attention to the participation in this round table. So once again, thank you for the possibility to exchange opinions on the issues with colleagues from Russia and colleagues from other countries. As for the Chinese situation and the openness of legal services for international practice, I would like to make a small introduction, a small overview of the situation in China. Actually, legal services in China have developed in a peculiar way. So the lawyers community has existed basically for 30 years. From the end of the 1960s and the 1970s. This process was initiated after the Great Cultural Revolution, and over the past years, this process has been greatly affected by the Cultural Revolution. The Ministry of Justice develops the pool of lawyers in China, but they don't have a very long history. So that's why, if you are interested in the situation in China, are well aware of this fact. After the 30 years of development, the lawyers community in China has been developing very quickly. The quality of legal services has been increasing gradually up to now. Over the 30 years of efforts, we have now 210,000 professional lawyers. Of course, China is a huge country, and for such a country, even this number is not adequate, but is not sufficient. But we are very serious about the developing of this area. We set up an examination system for these positions. We have capitalized on experience of many countries such as UK, Korea, Germany, France, amongst European countries. And the lawyers community is developing on a regular basis in China, and their professionalism has been improving. As for legal and lawyer services, with the development of the Chinese economy and the development of the openness policy over the last 30 years, it seems to me that legal services and lawyers' practice have shown an impressive development and made a breakthrough. I've already mentioned the short history of the lawyers community, but actually the lawyers practice is paid great attention to by the government. We are admitting officers of foreign law firms. We are expanding opportunities for their activities. Initially, they could work only in 5 Chinese cities. Now, the number has been increased up to 19. Secondly, after China entered the World Trade Organization, we have admitted more than 100 foreign law firms offices and offices of law firms from Hong Kong. So this activity is developing actively in China. After the WTO accession, we have committed ourselves to introducing a number of measures that have been implemented. First of all, to remove barriers with regard to the number of foreign law firms offices. So this first restriction was to be removed, and second thing that we did is to allow foreign firms' representatives to sign long-term contracts for providing legal services in China. And the third thing that we were to do is to ensure that representatives of foreign law firms can present foreign interests in China. So now these offices, based on the Chinese legislation and the international law, can provide a wide range of services in China. They can also set up long-term relationships with Chinese customers and Chinese law firms, which testifies to the fact that China meets the requirements of the global legal services market. After the accession in WTO, we have met all our international obligations, and it testifies to the openness of our country. Regulations were adopted for the activities of foreign law firms. So these rules now are the main document that regulate activities of foreign law firms' offices in China. Guidelines of the ministry regulate the foundation of offices of foreign law firms, their organization, their liquidation, appointing representatives, and so on.
Since the moment the legal services market was opened, and until March 2012 this year, on the territory of China, 319 representative offices of law firms from 22 countries of the world were opened. These representative offices are located in 12 provinces and districts of China, as well as in the cities of national importance, but the majority of them are in Shanghai, Beijing and Guangdong province. There the concentration is the highest. As far as the distribution of those offices by country, we can say that the largest number of offices were opened by American firms, the US firms. There are 110 of those. The second place is occupied by the law offices from the Special Administrative District of Hong Kong. They opened 68 offices in mainland China. The third place goes to law firms from the EU. They have opened 44 offices in China, followed by Japan in the fourth place. Japan has opened 19 offices in China to date. In the fifth place are Australian law firms, which have 12 offices in China at the moment. Therefore, the offices of the 5 aforementioned countries and groups of countries account for 79% of the total number of law offices, foreign law offices opened in China. Here there is a different question. Mr. Lyubimov probably knows about that. We are currently trying to increase the quality of law services. We expand the number of international law firms, but as far as I know, we don't have any offices of Russian law firms in China. We would wholeheartedly welcome Russian law firms in our country. We would like them to open their offices in China as well. According to the existing laws, offices of international law firms in China can provide consultancy services in relation to national laws, international law, or international conventions. Representative offices of international law firms in China generally provide a high level of service both to Chinese and international customers. They facilitate the influx of foreign investment into the country. At present, many Chinese and Hong Kong law offices cooperate with local law firms on a permanent basis. They have signed agreements with them. They have established stable and long-standing partnership relations with domestic law firms, and jointly they participate in large-scale international projects demonstrating a very high level of cooperation. In accordance to the rules established by the State Council of China, offices of international law firms in China all their activities in terms of establishing such offices, running such offices, and exercising control over the work of international law firms is carried out by the Ministry of Justice and local departments of the Ministry operating at various locations. Not only international law firms open their offices in China, I have to say that Chinese law firms in recent years have opened quite a few offices abroad. They open subsidiary firms in other countries, and at present quite a few Beijing, Shanghai and Guangdong based law firms have established their subsidiary structures in the US, in Germany, in the Netherlands, in the Special Administrative District of Hong Kong. These subsidiary structures for the most part help Chinese companies to participate in IPOs, to make investments, and they also assist foreign entities that are willing to invest in the Chinese economy. And I would like to also say that China is continuing to open up for the world around. We are now developing relations with a huge number of countries in the field of legal services. We have established active contacts with legal bodies of 96 countries and regions. We have signed more than 30 bilateral agreements with the authorities of justice in other countries. In 2007, as you know, we signed a bilateral agreement on cooperation with the Ministry of Justice of the Russian Federation last November. in the course of the visit by the Minister of Justice of Russia to China, another very important agreement on cooperation was signed that included a specific plan of action. Therefore, appropriate bodies of authority of China are actively pursuing international cooperation, and they are willing to continue opening up the Chinese market of legal services for foreign companies and entities. Of course, the most important thing is to satisfy the needs of our international and Chinese clients. In this way, we will be able to stimulate the development of economic and cultural ties between our countries. This is briefly what I wanted to say. Thank you very much. Спасибо.
With what we heard about Korea, namely, it does help to liberalize access to the legal market in a given country, because it helps foreign investment in the country, and it improves the quality of the legal service, which is needed, but it can be very wise to do that not overnight, but to do it gradually in steps and phases, where you begin slowly and then with experience gained, you open up further and further. In a controlled way also to ensure that the foreign lawyers in the country comply with the regulation, which is important. And I think it was also very remarkable to hear from you that there is not only this inbound view, foreign lawyers coming into the country, but that there's also an outbound potential, namely that local firms over time gain the experience and know-how so they can go abroad and open offices abroad in other countries and follow companies from their own jurisdiction which engage in international activities in other countries and continents and help them there, so that the entire story repeats itself, except it is now the opposite direction. And that shows that once you have done it in a good way, you can benefit from it twice. You can benefit for your market at home, but you can also benefit insofar as your law firms are enabled to go abroad and assist their clients abroad in other countries. Now, we have had 2 country reports, most interesting reports for Korea and for China. And I would now like to invite Akira Kawamura to tell us a bit about the Japanese experience. Akira, why don't you sit here and take my phone?
Thank you, Hansio, again. Japanese experience in opening up the legal market was very much rewarded and successful. But it took long time. In 1977, a major New York law firm, very well-known, Milbank, Tweed, Hadley, and McRoy, very well-known law firm, opened an office in Tokyo, which was reported by a local newspaper as the black gunship came back to Tokyo Bay again. As you may know or not, in the early 19th century, Japan was a very strictly closed from the outside country and has a centuries-long diplomatic isolation. Then the three black gunships led by Commodore Matthew Perry of the United States Navy came to Tokyo Bay and opened up the Japanese border by the power of force. And this newspaper report was analogous of that historical incidents. And the foreign lawyers to Tokyo was such big shock to all of us. But since then, we dealt with this question as a matter of international trade. And another interesting thing, in the middle of 1970s, the well-known American newspaper, New York Times, reported that they wrote, America, that time there was a trade conflict between Japan and America, and the United States was complaining about the amount of the import of Japanese cars into the American market. And that the newspaper said, America should export one American lawyer to Japan against importation of each Japanese car to offset the trade deficit. That time America had a big trade deficit against Japan. And that newspaper, that article meant that the trade deficit of American car was caused by a heavy litigation cost caused by the American lawyers. So if they export the American lawyers to Japan, Japan will have a same problems. That was what they meant, but that is, of course, not the case. But this is interesting. The trade in legal service problem started as a trade deficit problem. And then we were forced to open the market for the trade deficit, not for the growth of cross-border legal service or global legal profession. But we deal with that question by introducing new law on the legal service, foreign lawyers service. We made a special measures act for the foreign lawyers and their legal practice in 1986. And I was in charge of this question in the Japan Federation of Association. I took part of the drafting the law, and we made the law very carefully. And we started to introduce American lawyers and European lawyers to Japan. At the first stage, just 3, then it going up, and at the end of that century, we had 80 registered foreign lawyers. That time, the largest Japanese law firms, like ours, was just 50 lawyers. Since then, this century, first part of this century, as you know, the financial market boomed and international legal transaction went up very much. And we were very busy until the Lehman Brothers collapse. And the foreign lawyers in Japan increased from 80 to 300 some, well, less than 400. Big growth. But the large Japanese law firms grown up very much. Our firm grown up from 50 to 350. The largest one grown up from 50 to 500. In the meantime, total number of Japanese lawyers just increased twice. Last century, the number of Japanese lawyers was 14,000. Now it's about 30,000. So nearly 2 times. You may see that how remarkably the Japanese large law firms grown up in this boom economy time. And the Japanese law firms grown up much more than foreign competitors in the Tokyo market. So key is the host country must introduce a very well-designed legal framework whereby the foreign lawyers could practice very well. And secondly, we must make it sure that skills transfer is properly being made. The international lawyers are very good at using a very advanced legal technologies. Such high skills must be shared with the Japanese competitors. We must make it certain that is realized fair and reasonable way, whereby the market as a whole may grow up very much. More importantly, the legal education system, training system, must be very well improved. Traditionally, the Japanese lawyer training system was just to make litigation lawyers, court of officers, barristers, high, very reputable profession, noble calling. But that was gradually changing in the same period. And the legal training system was improved to make a good business lawyers who can handle international matters. It's on the process. It's not yet completed, but that is another thing. Skills transfer and education, they are very important key things. To make it properly, you should have a good statutory legal framework whereby the foreign lawyers could practice well. Thank you very much.
Thank you, Akira, for this contribution, which miraculously was very much in line with what we heard earlier on. Namely, open up, but do it gradually, do it in a controlled way, and it will help the economy at large, and it will help not only the foreign law firms coming in, it will also help your own law firms. And the Japanese example is a wonderful example because you have demonstrated how much stronger the Japanese law firms have become on a global scale. And you have introduced 2 new aspects which I found very important. You spoke about skills transfer and you spoke about the quality of education. Skills transfer, I'm speaking from experience. After my law education in Germany, I worked in an American law firm in 1968. And it is there that I learned transaction skills. The law is different, but the working techniques are very, very much the same because they are controlled not necessarily by the law, but by the problem that is on your client's desk and on your own desk and that you must solve. So I learned the working techniques. And from my experience, I can only say the best way is to learn these skills is to work together. Two independent firms, but even better, a foreign lawyer next to a local lawyer in the same firm. In my mind, the best way of skill transfer. And the other remark that you made was the aspect of the quality of education. There has been a fear over decades that opening up legal markets will reduce quality. I think the opposite is true. Transaction skills have improved, and there is now a pressure to even bring up education levels, because by opening up, you learn about the advantages and positive aspects in the education methods in other countries, and you learn from that again. So there is an increase in quality of education, which then increases the quality of the work for the client. I found that extremely interesting. We had three reports from countries in the Far East that have opened up in the last decades, and in all three reports, the message was extremely positive for both sides. It is truly a win-win situation for both sides, provided you do it carefully. Now, there is another country which traditionally has been extremely liberal when it comes to the regulation of lawyers that want to go to that country, England and Wales. And we learned that the example of England and Wales has been scrutinized by countries in the Far East to see how do they do it, and what is the secret for London as a legal marketplace to be so successful. Now I call on Alison Hook to share with us some of the experience that she has gained in her long career with the Law Society of England and Wales. And Alison, why don't you tell us your secret?
Well, now that I no longer work for an official organisation, I can give away these trade secrets. I will endeavour to do this. But first I would like to thank the organising committee and the city of St. Petersburg for allowing me to visit this wonderful place, and the moderators of this session, because I think it is, personally, I find it a fascinating subject. And I have travelled, I've been fortunate enough to travel all around the world talking to governments and bar associations and lawyers and law firms about this topic. And I find that even though the WTO is now perhaps, in terms of the Doha round, not making a lot of progress, it's very interesting to see how countries like Korea, like Malaysia, like Israel, like South Africa, are looking at this issue in its own right. And that's because legal services is not simply about, it's not simply a trade issue. There is a policy issue there for governments to decide what they want to do with the legal services sector. Because it is, in the case of Korea, I understand that there was partly a decision about building up the financial center of Korea, of Seoul, and making Seoul an international center for asset management. In Malaysia's case, the Malaysian government decided that it wanted to create a center for Islamic finance, and legal services are very much part of that, and so on. And all of this is also reflected in what is the London example, because in London's case, the successive British governments have taken the view that now that we can't make anything anymore, now that we have, everybody is better at everything else than we are, the only thing that we can still do that is world class is in the area of finance and legal work. And so legal services becomes a very big opportunity for the UK to grow and develop. And how has this come about? I think there are a number of different reasons. The first advantage that the UK had in developing itself as a legal centre was the fact that we had this traditional division between court lawyers and transactional lawyers. So we have barristers who went to court and solicitors who could go to court, but usually the lower courts, and were more involved in contracts and transactional work. And that meant that we had, and to give you an idea of the numbers, we have about 10,000 barristers today who go to court. We have 150,000 solicitors who are involved in transactional work, in the contracts, etc. And the court work was always much more heavily regulated than the transactional work, because court lawyers, even today, barristers, are not allowed to, they're just beginning to be allowed to work in partnership. They're not allowed to hold money from clients. They don't deal directly with clients. These rules are beginning to change, but for decades, for centuries, the court lawyers have always been very tightly regulated. Initially, and I think this is kind of the situation in Russia, that the transactional lawyers were pretty much unregulated. So really it only became in the 1970s that the government passed some legislation that provided for solicitors to be regulated. And what happened then was that certain areas were created as reserved areas of work. And these were areas which were there to protect the consumers and clients. So in areas like property transactions, so conveyancing of property, of litigation, so the preparation of documents to go to court, of the drawing up of probate, deeds of probate, so the wills. Every other area pretty much was open to anyone to do. So we always have this joke that if you want a divorce lawyer, you can talk to a taxi driver because he can give you, and taxi drivers in London are very good at giving opinions on everything. But so that meant that when foreign lawyers, the question of foreign lawyers coming in was raised, there was no question that you could require a foreign lawyer to be more regulated than a taxi driver when it came to giving legal advice. So essentially it was the fact that we had a relatively unregulated environment for our transactional law that meant that it was very easy for foreign lawyers to come in. Now what's happened since then is, but even then, solicitors, our transactional lawyers in England, were not allowed to go into partnership with foreign lawyers until 1990. And this was part of, now I get into the government policy making process, because this is where the government decided then that in conjunction with our financial services Big Bang and the attempt to create London as a big financial centre, once again in the 1980s and 1990s, that what we needed to do was to allow foreign lawyers to work in partnership with solicitors. So that only happened in 1990. So when is that? That's 20 years ago? I'm a bit lost in terms of time. And that brings me on to an interesting outbound point, because one of the reasons why English contract law is used so much is because we had this explosion in the capability and in the size of law firms that were doing financial services work and supporting investment, supporting global companies that wanted to go and invest and wanted to undertake cross-border activity. So it meant that when companies were looking for expertise, they either found it in America, in particular New York, or they found it in London. And that's why English contract law and New York contract law are so widely used, because it became a habit, really. And it will be very interesting over time as other countries start to build up more and more capacity and do more outbound work to see whether other countries use their own contract law much more. I find it very interesting to observe, for example, we now in London also have some Chinese law firms. And in talking to those firms in London, you know, one of the things that they say is the reason they're interested in coming to London is because they have clients who want to be in London. Now, clients always feel most comfortable with law firms or lawyers from their own country who speak their own language, who understand their own way of thinking. So I think the counterpart of opening up is then you see law firms going out from these countries. And I think the next development, which will be interesting to watch, will be whether there is then more work done in the laws, more international transactional work done in the laws of these other countries. I will move on to the next revolution really in England and Wales came in the late 1990s, where then governments decided, well, we want to reduce these areas of monopoly for solicitors and barristers and increase competition because legal services remain very expensive and consumers remain unsatisfied that they're getting the quality that they want. So other regulated practitioners were allowed to practice in certain areas of law. So, for example, we created the concept of licensed conveyancer, which meant that you could get a special license just to do property work, for example. And this is important because when a lot of people think about the deregulated nature of England and Wales, in fact, we have some very regulated areas, and those are regulated for the purpose of protecting consumers. So nobody is claiming that you should deregulate everything. I'll bring you on to the current revolution that's happening now in England and Wales as a result of another piece of legislation which was passed in 2007. And this reflects the latest concerns, which are that we need to provide better access for citizens to have access to better, cheaper legal services that they feel more comfortable in accessing, because lawyers' offices and lawyers can sometimes be intimidating for the ordinary citizen. But secondly, also that lawyers themselves should be allowed, perhaps, to go into partnership with other professions and should be allowed to develop their businesses by taking in external investment. And these are really quite radical issues that raise a lot of questions about how you can do that whilst maintaining the independence of the lawyer. Now, we in England and Wales have gone about this in a regulated way. So it's not simply a matter of saying now a law firm can take investment from anyone. There is a licensing process where if a lawyer wishes to go into partnership with an accountant or wants to list on the stock exchange, for example, what they must do is apply for a license, and that license has many, many conditions and is also controls the role of the lawyers at the center of the business. The other aspect of this legislation that I mentioned was the professionalization of regulation, because in the past, regulation was delegated by the government to the Law Society of England and Wales and to the Bar Council. And it was felt that the lawyers had perhaps too much self-interest in protecting their monopolies, limiting how people could join the profession. And even if that wasn't the case, it was the public perception that that might be the case. So what government wanted to do was separate out representation of the legal sector, representation of the profession from its regulation. And it's done this in a typically British complicated way, probably more complicated than it needed to be, But what it means now is that regulation is still independent of government, but it's also to some extent independent of the representative interests of the legal profession. Now, I bring all of these different points together to really stress three things which I think I would like to stress for this discussion. The first is that underlying all of this debate, we have to acknowledge that there are government policy purposes at work, and that those also can shift over time. So maybe in the past the focus was on exporting legal services, or the focus was on demonstrating how open an economy we have. Now the focus may be more on how do we ensure that the citizens have best access to legal services. The second point is that it's not about removing regulation, and trade in legal services is not about an open door or a closed door. It's about getting the right regulation. And I think this means not only focusing on the regulation of the foreign lawyer, but also on the regulation of the domestic lawyer. Because sometimes I see governments put a big emphasis on the rules about foreign lawyers, and they forget when they may be hampering, they may be preventing their own lawyers from competing effectively against the foreign lawyers. And this happens in a number of ways. We see law firms in some countries, like India, for example, they're not allowed to have more than 20 partners. In some countries, like, well, many countries, lawyers and law firms are not allowed to have websites. And that's maybe very good for, you know, the sense of the nobility of the profession in that country, but it's not very good for the local lawyers if, when a client, a potential client, is looking for advice, and they enter into Google or Yahoo or whatever, I want a lawyer in Croatia, and what they come up with is an American law firm, because the Croatian law firms are not allowed to have a website. And so I think it's very important that regulation evolves both domestically as well as internationally. And my final point really is just to stress again that the world doesn't stand still. And even in the UK, now having embarked on this journey of exploration in terms of allowing non-lawyers to participate in law firms as partners and investors, we're now considering other issues such as partial licenses for lawyers. So could you get a lawyer, could you get a legal qualification that allows you only to be an expert in this area or that area, rather than a single license? And secondly, the renewal of licenses. So just because somebody qualifies in 1950, by the time it gets to 2010, are they still, aware, have they kept up to date? And many countries are trying to deal with this through continuous professional development, but we have to ask ourselves whether that is actually doing enough. And then finally, I would just say that one other issue that we should try and talk about as a panel is the role of company lawyers, in-house lawyers, in this process of trade, because they play an extremely important role in terms of trade and corporate governance. So that's all I would say for the moment. Thank you.
Thank you, Alison. Very interesting contribution again. And it's amazing to see how well that contribution fits into the three contributions that we heard before. It is amazing to see that here you have England and Wales, you have the financial marketplace London that has benefited from opening up their legal markets to foreign firms. Not in the sense that foreign firms could not work there before. No, they could. They were liberal. But they had a restriction on association. And with the Big Bang of 1990, which was a financially driven Big Bang, they opened up in order to allow association, which means in order to allow transfer of skills, transaction skills, and that has made the London firms grow and become so important in the world. You mentioned, Alison, the example of India, which has a limit of 20 partners and not more per Indian law firm. There was a similar limit in effect in England, which was not from the regulation of the profession, but it was general partnership law. General partnership law in England until the mid-60s of the last century said, stop it at 20 partners. You can't have more than 20 partners. And then someone asked the question, is that meaningful in today's world? And they removed that altogether. And that enabled English law firms to grow and to become important players in the marketplace. What we also learned from you is that you have a market that is liberal to law firms coming in from other countries, but these law firms from other countries then benefit from regulation, but they can also be suffering from new regulation that comes in, for instance, when regulation is being tightened up on certain aspects. And that is an interesting trend. You have deregulation in England and Wales in certain respects, but you have a strict regulation in other respects when it comes, for instance, to the duty of a lawyer to do continuing legal education, which is very strict in England and Wales. If you don't do it, you lose your license as a lawyer. And that is something that then also can have its repercussions on foreign lawyers working in the country. May I suggest that you all of you now consider which questions you would wish to put to the 4 panelists that have given their presentations so far. And we give you how much time for the break? 20 minutes? 15 minutes break, coffee break, to reflect on this, to fresh up, and then come back and start your questions to the panelists. And then we'll go on after that short discussion phase. We'll go on with the remaining contributions from our panel. So we meet again in 15 minutes from now. Thank you for your attention. 11 o'clock back in the room. Well, if you have no questions right now at the moment, then I suggest we go on with the speakers on our panel. Our next speaker will be Alexander Muranov. He has already been introduced from Russia. He has already been introduced by the IBA president, Akira Kawamura. That here, what I have here in my hand and what I show to you is another piece of introduction for our good friend Alexander. It's the following. The IBA, a while ago, has published a handbook on the various issues surrounding the WTO, the World Trade Organization, and the GATS, the General Agreement on Trade in Services. It's the GATS handbook. It was written in particular by Professor Laurel Terry from the United States. And it's a book that introduces lawyers to the subject area of GATS and WTO, which is, at first sight, a complicated subject matter. And that book has been printed in over 6,000 copies, and it has been published in English, but translated also into French and Spanish. It's been distributed all over the world, and Alexander has done the fantastic job of preparing a Russian translation of this book, a condensed version in Russian. So if you want to familiarize yourself with this subject matter, just look at this Russian translation that Alexander has prepared. Alexander, you are now going to speak to us about the Russian experience and the Russian view when looking at the WTO and the GATS, the General Agreement on Trade and Service. The floor is yours.
Thank you, Hans-Jürgen. But I will going to speak about the Russian experience in the context of the global experience. But first of all, a few words about what is international trade in services, not in abstract things, but in figures and statistics of the World Trade Organization. I'm sorry for the small screen. You can't see properly, but in 2008 the total volume of the legal services market amounted to almost 600 billion US dollars, and the growth before the crisis of 28 amounted to some 5% per annum. Today the market contracted. It is $500 billion. But after the post-crisis recovery and the recovery of economies, it will reach $650 billion. In absolute terms, it is a huge figure, and what is interesting to indicate is that in the global economy, the legal service market and trade therein accounts for 1 to 3% of a GDP. On this graph, you can see shares of different regions in the global legal services market. The USA is the leading country, followed by Europe, Asia. The USA and Europe put together account for more than 50% of the total market. Some more figures. For example, if we take the UK, that we have heard about today, an interesting report, it accounts for $30 billion. And the growth rate before the crisis was about 4%. And England is amongst the leaders if we look at the share of legal services in its economy, 1.8% of its GDP. As for Russia, if we compare Russia and UK, unfortunately, our indicators are 5 times lower. That is 0.36% of the GDP. However, when I carried out these calculations, I actually thought that it was much smaller, but it turned out to be not such a small market. And why is it small? The explanation is very simple. Very little time has passed since the time when it was possible to develop the legal services market properly. Obviously, it couldn't develop in the Soviet Union, and I think that in the upcoming years our market will show an impressive growth. And these are figures pertaining not to domestic markets but to trade, export and import of legal services. As you can see, the USA and the UK have the scope of the market of $7 or $8 billion, while the import is lower, $1 to $2 billion. And here are Russian indicators. If we look at the share of legal services in our foreign trade, we'll see that it accounts for less than 1%. It is less than in other developed countries, but the explanation is the same. Too little time has passed, and I think that gradually this gap will be filled in. In Russia, unlike in USA and Russia, import dominates. We have a certain deficiency, and if the legal services turnover is about $1 billion,
юридические услуги оказываются из-за границы потребителям,
then mainly these services are provided by foreign actors, and this negative balance is growing. So 2 years ago, the negative balance was 80 million US dollars. Well, some more indicators that are quite impressive. If we calculate from 2002 up to now, over the 9 years, the turnover has increased fivefold. So the growth of some 50% per year is quite impressive. As for export, the indicators are even more impressive. Over the 9 years, we have shown a 9 times growth, so basically almost 100% each year. Import has increased 4 times over the 9 years, that is 4 times less than export. The main counter-agents of Russia in trading in legal services, the largest share of legal services is imported to Russia from UK, USA, France, the Netherlands, Germany, Sweden, Ukraine, Cyprus, and Finland. But at the same time, the largest receiver of services from Russia, mainly from foreign law firms present in Russia, USA, Cyprus, UK, Germany ranks fourth, France, the Netherlands, Japan is on the 8th place, and Switzerland is on the last place. Now about regulating trade in legal services. Today we understand more and more clearly that international trade in legal services is regulated not only through internal regulatory instruments, but today many lawyers, not all of them, but they do know that within the framework of WTO there is a multilateral agreement that encompasses legal services inter alia, the General Agreement on Trade in Services. There were different opinions when drafting this document. There was one opinion that legal services should not be embedded, but nevertheless the inclusion dominated. And this is the most important document that currently regulates trade in legal services. But it is necessary to understand that GATS does not say how lawyers from one country should render services to consumers in another country. This document does not regulate rights and obligations of lawyers and legal services consumers. It regulates WTO members' activities. Due to this agreement, the member countries committed themselves to liberalization of the legal services market, allowing foreign firms and companies, lawyers, to come to their markets to ensure a higher competition level in the countries and to allow consumers to have access to a high quality of legal services and as well as fostering investment. So the essence of GATS is to allow states to impose self-limitation and not to introduce barriers to providing legal services at the international level. And the IBA has prepared the publication mentioned by Hans Jürgen that describes in more detail than I'm doing now how the GATS agreement is applied. Each country, when joining WTO, takes obligations commitments with regard to specific countries. They are presented in tables, so this is a table for Russia. It is very small and actually it is full of meaning, and it may take dozens of pages to explain a specific provision. Similar tables are included in the commitments of all other WTO members. Due to them, lawyers from different countries do know in which case a WTO member may impose a restriction or when it cannot be done at all. So the GATS is an instrument that allows us to plan and to carry out activities on the conditions that are well known in advance, which in our current world, with states having different regulatory frameworks, is of paramount importance. Russia, as planned in July, must become a member of WTO, and then the GATS agreement will be applicable with regard to Russia too. And what is the peculiarity for Russia in this respect? Our legislation on regulating activities of lawyers and rendering legal services is actually rooted in the Soviet times, and in the Soviet Union the notion of trade in services wasn't used. So today we are faced with the following problem. According to the Russian legislation, lawyers are not persons trading in services, but persons rendering legal aid. So when in Russia we say that, there is such an agreement regulating trade in legal services, these lawyers say that it is impossible. We are not covered by this agreement because we don't trade in services. We render legal aid, which is an absolutely different sphere. They do not understand that the peculiarity of the terminology of WTO is such that even notaries' activities are actually about trading in services and nothing else. So this legacy of Soviet law, I think, will have an impact. And the implementation of GATS in Russia may come across certain difficulties. But I think that we will be able to overcome them. And in the end of the day, all the lawyers in Russia will understand that they are governed by this WTO GATS agreement. Apart from this global agreement on trading services, of course, lawyers' activities are regulated on a bilateral basis, namely free trade agreements between countries. Well, I picked up the USA as an example.
The US may be one of the leaders in this field because they participate in two regional agreements. That's the Northern American Agreement and the Central American Agreement on free trade. And also the provisions of these agreements cover the trade in legal services, and thanks to these agreements, lawyers from Mexico, the US, Canada, Latin American countries can provide services not only at home but in other countries part of the NAFTA area. This also facilitates the development of these markets and of course the clients are able to obtain additional services. The US signed 9 agreements on free trade with other countries such as Israel, Jordan, Chile, Singapore, Australia, Morocco, Bahrain, Oman and Peru. In 2 agreements, the North American Trade Free Area and in the agreement with Chile, the legal services are mentioned directly. It is not it was not usual some years ago, but now it is quite ordinary to mention legal services amongst those services that need to be rendered without any additional barriers, according to those agreements. Now we're talking about a trend, and this trend means that free trade agreements cover not only on goods as before, but they more and more cover services and legal services in particular. Now about the situation in Russia in this respect. All agreements, international agreements of Russia, can be divided into three categories. Number one, bilateral agreements on free trade. We have signed about 10 of those. Those are agreements with the former Soviet Union countries, with the exception of Serbia. Serbia is the only exception from this rule. But all these agreements cover only the trade in goods and not services. Or they can cover some services related to the trade in goods, for example, transport services. The second type of agreements are multilateral agreements on free trade. Again, those agreements were signed only with the former Soviet Union countries. And one agreement of this kind was signed with the European communities in 1994. Now they've almost finished the preparation of the next version of this agreement with the European communities. So these agreements do cover the trade in legal services, but in contrast to GATS, they are of a declarative nature. In other words, the country announces that they intend to liberalize this sphere, but this is just a declaration, not more than that. And these declarations have not led so far to any practical steps. But we can also observe a revolutionary phenomenon here. 2 years ago, three former Soviet Union countries, Russia, Belarus and Kazakhstan, have entered into an agreement on the trade in services and investments. And this is the only agreement which is currently in force between these three states, which is similar, which is equivalent to the GATS agreement. This is a mini GATS, if you will, which covers these three countries in structure and in mechanisms of implementation. It is similar to GATS, and it is for the first time in the history of Russia that an international agreement mentions legal services, particularly provision of legal services by lawyers from these three countries. Russia has made a first step. Everything started from the creation of a small single market of legal services. And we created not a declaration, but a mechanism, a real mechanism that enables the provision of legal services in Russia, Belarus and Kazakhstan without any additional limitations. In spite of the fact that Russia is lagging behind many developed countries in many respects, there is no doubt that we see progress in this area. It is supported by numbers, by statistics. The development of the legal services market is quite impressive in Russia, and I have absolutely no doubts that this first step that was made on the way to first establish a single market of legal services on the post-Soviet space will continue into the future. And of course the accession of Russia to the WTO in summer this year will give another impetus to this development. So I think that the development of the legal services sphere in Russia and international trade in services and legal service in Russia is a promising sphere if you know how to work with it, how to invest in this market. So if you do know this, the result will come. And this will be for the benefit of Russia, the Russian legal community, and also, I think, for the benefit of other countries. Thank you very much.
Alexander, thank you for this presentation. I think it was very, very useful for all of us that Alexander has begun his presentation by showing some statistics on the economic side of it. And it has shown, very importantly, the growth in terms of GDP figures, trade balances, and so on. I think that is very important. And undoubtedly, to find out these statistical figures, Alexander, must have been difficult. Because we know, Akira, remember the discussions we had in the IBA to find out about these statistics. So congratulations on these figures and that you collected them. Alexander has done something special too, also in the following respect. He has given you really an insight into the toolbox that countries can use when deciding on liberalization cross-border. It all starts with a country deciding to voluntarily liberalize without any international commitment whatsoever. They just do it because they think it's advantageous for the reasons that we've listened to, that we heard this morning. So we have voluntary liberalization. We then have liberalization under the WTO GATS, which is a liberalization where countries commit to each other what they will do in the liberalization of certain services, including legal services, what they will do and under which conditions they will do. And that creates a binding commitment on such member state. Unfortunately, we lawyers, we cannot derive directly any rights from the GATS agreement. So if a country does not fulfill its obligations under the GATS agreement, we can only go to our own country and tell them to complain. But we lawyers do not derive benefits from the multilateral GATS agreement. And the third tool that Alexander has mentioned is the bilateral free trade agreement. For certain reasons, bilateral free trade agreements, and he has given examples, have gained in importance and have now probably even more importance than the multilateral liberalization through the GATS, which is understandable. GATS has achieved a lot, and every additional millimeter of progress on a worldwide scale becomes more difficult. And that is why many countries now use the bilateral free trade agreement approach. And then Alexander has also mentioned something which I will talk about at the very end, namely regional liberalization. He has mentioned the NAFTA, the North American Free Trade Association, the European Union, and the liberalization of legal services in the European Union is a regional liberalization. It is somewhere between the worldwide multilateral GATS on the one hand and a purely bilateral FTA on the other hand. So Alexander, thank you for this presentation, which really has outlined the entire toolbox that is available to states when they want to do something in order to open up. And again, for your first part, demonstrating the economic importance of actually doing this opening up. We now turn to Ben Greer. Ben Greer, so to speak, is the father of the activities of the IBA in the subject matter that we are presenting here today. Many years ago, when he created a WTO GATS working group at the IBA to advise the Council of the International Bar Association on this developing area and to help Council to draft resolutions of policy whereby the International Bar Association could assist this process of negotiations on the one hand and of implementation on the other hand. I am now, so to speak, sitting on the chair of that working group that was founded many years ago by Ben. And Ben, it's a great, great pleasure to me to invite you, so to speak, as my grandfather on the chair, as to invite you as my grandfather to give the presentation to us of how you see the role of the IBA and in particular of your personal experience on this subject matter. Ben, the floor is yours.
Well, at least he didn't say Godfather, so thank you, Hans-Jürgen. And let me thank Mr. Lubimov and the organizers for organizing a marvelous conference. This has been a wonderful professional experience, and I should also thank our IBA's president, Mr. Kawamura, for inviting me to be a part of this panel. It is a distinct honor, and I do appreciate it. I will speak a bit about my personal experience because it has been relevant to what we've been doing in the IBA, I think. I practiced 40 years as an international business lawyer with law firms in New York and Atlanta, Georgia, mainly in Atlanta, Georgia, for a large firm, one of the largest now in the country, and was in charge of the firm's international practice for a long time. We branched to other cities later in my career, but we were only in Atlanta in the 1980s when I joined the firm. Atlanta is, I don't know if many of you know it, but it's a city now of 6 million people. It is the international commercial and financial center of the southeastern United States, which taken together would be the 6th largest economy in the world. So we don't claim to be New York or London, but there's a significant amount of international commercial activity that comes to and through our jurisdiction. My interest in regulatory issues began in the 1980s because our bar made its rules on admission more restrictive. And that meant that our firm was not able to compete effectively for talent with firms in New York and a few other jurisdictions. Back in the 1980s, the U.S. Had a few open jurisdictions, but most were closed, like ours. And so since that time, I have been working with our state bar, first as kind of a Don Quixote alone, but now as the chair of our Committee on International Trade and Legal Services to liberalize our rules. Now, when I say liberalize, all of us on the panel have said liberalize in one way or the other. That does not mean deregulation. That means a change and modification of rules to eliminate unreasonable restrictions so that lawyers can practice in accordance with the way business is done. And so that's how I got started in all this, long before I began to work on these issues in the IBA. I don't think anybody knew about that background when I was asked in 1993. This was before the GATS was adopted. The WTO agreements went into effect on January 1st, 1995. But I was asked by the chair of a committee that I sat on to help draft a model rule on what became establishment, that is, foreign lawyers practicing in another jurisdiction and the circumstances under which that practice would be sanctioned. That was extremely controversial, to say the least. But for the last 19 years now, I have been involved in that effort and others to develop a consensus within the IBA's member bars on how these cross-border regulatory issues should be addressed, because globalization is a fact, the mobility of lawyers is a fact, and regulatory authorities need to deal with that fact. They cannot build walls, and they cannot ignore these central facts of our age. Now, Hans-Jürgen and Alexander have said much about the GATS, and I won't say too much more, but I will tell you, because it's kind of interesting, we were working on this establishment issue before, as I say, the GATS went into effect. But in 1994 at an IBA conference, I heard a speech by the chairman of the International Federation of Accountants, who put a PowerPoint slide on the board saying, this is the World Trade Organization as it will exist after 1995. The rules on legal services will be subject to GATS prescriptions after that date, and we accountants are going to use the trade rules to force ourselves into the area of legal practice through what we then referred to as MDPs. That's a much different question today than it was 18, 20 years ago. And so that caught the attention of a number of us, and we began to, at the IBA level, to take an interest in the impact of the GATS rules, which are very general. The GATS rules, I should say, on professional regulation. Other professions for WTO member countries are also regulated by the GATS. And there are basically three very general prescriptions that apply to all of those professions. First, that professional admission to the profession be based on objective and transparent criteria that test the qualifications of persons seeking admission to the profession, that any regulation be no more burdensome than necessary to protect the public interest, and finally, that licensure in itself should not constitute a restriction on admission to practice. So, as I say, we got interested in this after the accounting profession, through its official body, basically threw down the gauntlet and said we are going to use this process to gain legal authority to practice law virtually worldwide. Now, bars are very emotional, and there's a protectionist element to the feelings of bars. There's also a strong feeling among lawyers from every jurisdiction that they do perform a public service, and that tampering with the traditional structures of the legal profession in the discharge of those public duties should be approached very carefully. And so we went to the WTO and had a briefing for our leadership, and we've had regular contact with the Secretariat ever since that time. Now, before going on, let me just sort of ask you to step back and think about the whole issue of regulation. You've had examples of this in the presentations this morning, but regulation basically is a patchwork. If you look at it's nationally based by and large, and if you drawn from many legal traditions, and it is it is controlled generally by regulatory authority, mainly independent of the government, in those jurisdictions, and viewed against what lawyers actually do, there is a dramatic contrast. And the GATS sort of forced us to focus on this in a way that over time I think has been very productive for the legal profession. But just think about it. Lawyers travel, lawyers sit at their desks sometimes, dispense legal advice electronically outside their home jurisdiction. They receive advice. They develop client relationships electronically. They never have to leave their home jurisdiction to be involved in international commerce. Law firms obviously form branches in other jurisdictions, and they also have formal and informal networks, and where permitted, and this is increasingly a fact of life, not necessarily in the manner first contemplated by the large accounting firms back in the 90s, but there are multidisciplinary practices that are sanctioned by many, by regulatory authorities in many jurisdictions. And that poses challenges to jurisdictions like ours, which do not, at this point, permit multidisciplinary practices. And there are new forms of practice every day. Lawyers are very creative people. And if the regulators say, no, you can't do that, and if the lawyers feel that they can serve their clients better by doing something else or by finding a way to avoid specific prohibitions in a given jurisdiction, they'll do it. That's what they get paid to do by their clients. And there's nothing wrong or sinister about that. That's just effective legal representation. So in any event, there's a great contrast between this national regulation and the reality of modern practice, and not just, it's mainly commercial practice, but it's not just legal practice. The general counsel of our bar called me a few years ago and said, look, I've got a Mexican in a rural county in Georgia, and he's demanding the right to plead before a court there. And the judge called him and says, what do I do? I've got this Mexican lawyer who says that he's got a right to plead, represent a client in my court. Well, under the NAFTA treaty, there are rights to plead before local courts. So this was a big problem under our rules at the time. We fixed it. But this affects litigators less so than commercial lawyers with large firms. It affects small firm and large firm practitioners just because of the pervasive effect of globalization. And there are new challenges every day. Last week, literally before I left, we got a call from a law firm in our state. Can they enter into a partnership with a lawyer from another jurisdiction outside the United States? And there's a prohibition against fee sharing. So we have to deal with that in a way that is consistent with the GATS rules, which say you can't be any more burdensome than to protect the public interest. Well, if this lawyer is well qualified in, say, Canada or the UK, and is dispensing only that law in only that jurisdiction and is in good standing there, why not? So we have to find a reason consistent with the GATS to deal with that issue. Now, as I've already suggested, regulation is inconsistent. Some jurisdictions, as you've seen this morning, are very open. Some are mixed. They're all evolving, but at different speeds. And let me ask you why it matters for organizations like the IBA to take a large interest to develop consensus on these issues. And the reason it matters, if you were at the plenary session yesterday, almost every speaker mentioned the rule of law. The rule of law is essential to the protection of property rights, economic development, and the protection of human rights. And I'll give you my own personal definition of the rule of law. It's like a chair or stool with three legs. The first leg is laws that make sense and are supported by a consensus that's consistent with national and international norms. The second leg is an independent judiciary free of political influence, also a competent judiciary. And the third leg is a competent and independent legal profession. And so that's what the IBA is taking. That's our focus in the IBA is to enhance the rule of law by ensuring that lawyers and the regulation of lawyers is done in a manner not only consistent with the GATS, but in a way that promotes public confidence in our institutions, because that's really what matters here. And so what has the IBA done? The IBA is, for those of you who may not know, is an assembly of representatives of bars of, I believe Akira mentioned this morning, 137 countries. There's no other organization has that kind of representation from national, mainly national bars. Some countries don't have a national bar. So, but it is a body that, when it reaches consensus, can speak for the worldwide legal profession. And so what we have done with the GATS is, over a long period of time, we have our committee and its predecessors have prepared resolutions on various GATS-related issues that are submitted to Council for debate. And this has gone on for a very long time. This is not an easy process, because opposing views in this area are very often, well, they're always in good faith, I think, but they're very often diametrically opposed and emotionally held. So it has taken, on particularly contentious issues, it has taken a long time for us to reach consensus. And we don't pass our resolutions by a 51-49 vote. They have to be supported by a virtual consensus of 100% of our bars. Otherwise, we go back to the drawing board and we work on the issue again before we submit a revised resolution to the bars. The first resolution was on the core values of the legal profession, and that's what we support. Every other resolution has either expressly referred to the core values or implicitly incorporated them into the resolution. The first one on establishment, which was passed in 1998, so 5 years after the issue was first broached with the IBA, articulates a series of common regulatory principles on which all of our subsequent resolutions have been based. And they are, and I think it's worth mentioning here, the authority to regulate, the host authority, that means the home bar, has the authority and the legitimate right to regulate the establishment of foreign lawyers and the legal profession within its physical jurisdiction. However, such regulations must promote fairness and uniform treatment. They must be transparent. They must also serve a public purpose. This recognizes the public duties that we have in serving the private interests of our clients. They must promote the access to legal services that facilitate the effective delivery of legal services. And then we go into the circumstances under which this may be accomplished. And given different legal traditions, individual bars can accomplish those general goals by adapting their own legal system in ways that may not be consistent with the way, for example, that England and Wales have addressed the issue. So that was kind of a breakthrough once we got through that one, and we then have had a series of resolutions, some of them very specific and GATS related, because the Secretariat has been very interested in our input on helping develop terminology, on helping to classify legal services, because we don't fit in the same kind of box that architects and doctors and other regulated professions fit. And so we have been in regular contact with the GATS, with the GATS and its Secretariat on these issues. And we have now just recently, in IBA terms, in 2008, 4 years ago, finally addressed the issue of skill transfer. This was initially requested by the bars of some developing countries, and then, quite understandably really, they began to have second thoughts. They said, well, what are we getting into if we allow our lawyers to be employed by these foreign law firms that come in? And so we worked through that issue, and now the IBA Council has spoken and endorsed the idea, subject to all the other resolutions that we've passed, that the skill transfer is basically a good thing because it enhances the competence of the local profession, and again, the public confidence in the profession promotes the rule of law. And our next resolution, which is not yet finished, deals with an equally thorny issue, which is the circumstances under which local lawyers can affiliate with foreign law firms or other law firms. And so there's much to be done. In a lot of ways, this journey has just begun. The IBA is only one voice, but I think the most significant voice in developing consensus on how these issues should be addressed. I'm gratified to hear that our friends from Korea and China and other places are taking seriously the issues that arise from the globalization and the mobility of lawyers, because those are facts of our lives, and they're not going away. There's much to be done, much coordination, but I think we are started, and we at the IBA hope that we're making a valuable contribution to the enhancement of our legal profession, because we all share much in common, much more in common than we differ, and we all have a role in promoting the rule of law and public confidence in the legal profession and the work that we do. And I will stop there.
Thank you, Ben, for this personal reflection on what the IBA has done, and also giving us some insight into how you got into this activity in the very, very first place. You said that the IBA is there to enhance the rule of law, but you also mentioned when it comes to regulation, that is different from country to country. And I think when you combine these two aspects, everyone in the room will understand how difficult is the task of the president of the IBA, who has to deal with bars and law societies from far over 100, I think so, 137 or whatever countries, all with different regulations, and trying to get them to agree in a certain direction. Akira, that sometimes reminds me of a dompteur in a circus who is trying to control at the same time 137 tigers. But I think you, as well as your predecessors in the presidency of the IBA, you're managing extremely well. In particular, thanks to the help of someone like Ben, who has really been the mastermind behind these first resolutions that he has mentioned. He spoke several times of the Secretariat, just to that there's no misunderstanding. That is the Secretariat of the World Trade Organization in Geneva. And the IBA has become a counterpart in the discussions with the Secretariat of the WTO as a consequence of these resolutions that the IBA has been able to develop, adopt one after the other over the years. I am not aware of any other service profession that has been able to develop a comparable body of policy resolutions and thereby being able to enter into direct discussions with the Secretariat of the World Trade Organizations. That demonstrates to you how important this work is. And Mr. Yugimov, I want to mention one thing in your direction. We learned this morning about the beneficial effects of liberalization, of a controlled, gradual liberalization over time, of the beneficial effects in countries like Korea, in countries like China, and in countries like Japan. And that is something that we will bring from this conference back to the discussions in our committee and in the IBA at large, because it is getting more and more difficult to find consensus in the IBA. The first step of liberalization is relatively simple. But the more you go down the road, every additional step becomes more difficult. So the positive effects that this conference has demonstrated to us today will be a very, very useful input to the work that we do in the IBA. This leaves only one more presentation, and that is my own. And I'm going to speak about the situation in Europe, in the European Union, which is the closest form so far that I know of bringing together legal professions from different countries. They are national legal professions. And we learned this morning about the difficulties of bringing legal professions from different countries with different cultural backgrounds, regulatory systems together and to cooperate. And Europe, I think, has done the greatest step forward in terms of history in this respect. The starting point is a lawyer, also in Europe, is a national lawyer with deep historic cultural roots and with a national system of regulation. But nevertheless, there are some common rules that flow from the European treaties and that really have turned these national lawyers into lawyers which share certain aspects and which has given them a European mind. The first treaty was the Treaty on the European Economic Community of 1957, which today is the European Union. And already the first treaty has provided for two very basic fundamental freedoms, namely the freedom to render temporary cross-border service and to render cross-border service in a non-temporary form, namely by establishment in another country. So we are talking about the freedom of service, in brackets temporary, and the freedom of establishment. We learned earlier on about the difficulty, or say the dual face of a lawyer. He is an instrument of justice on the one hand and a service provider on the other. And that's why in the beginning it was questioned by the bars and law societies, do lawyers fall under these treaty provisions? Do they enjoy the freedom of service and the freedom of establishment? After all, they are instruments of justice, and that is public authority. And there's an exception in the treaty for public authority exercise. The European Court of Justice very early has held a lawyer is an instrument of justice, but he is also a service provider, and therefore lawyers enjoy the fundamental freedoms of temporary cross-border service and of establishment cross-border. That means that a Frankfurt lawyer like me, I have the right under the treaty to fly to Paris in the morning and return home at night, or stay a few days in a hotel in Paris, work for my client from Germany who sits next to me, or work for a French client in Paris and return home. And I also have the right to establish an office in Paris and move my domicile, my residence from Frankfurt to Paris and work in the Paris office. This is very different from the situation in the United States of America. In the United States of America, you have the Interstate Commerce Clause in the Constitution. But that Interstate Commerce Clause in the Constitution relates to commercial activities only. And it does not relate to the service activities, to the activities of a lawyer. So a lawyer from New York is in Florida a foreign lawyer just as much as a lawyer from Europe. So in Europe you have the unique situation that you have in the treaty the fundamental freedoms that give these cross-border rights. Now, the treaty provisions are very general, and the European Community has adopted several acts, legal acts, in order to lay down more details on these two fundamental freedoms. The first one is the Service Directive for Lawyers of 1977. It specifies the temporary cross-border service right. It basically says if you are a lawyer in one jurisdiction in Europe and you fall under a certain category of titles of lawyers in that particular country, you as a lawyer, as a finished product, so to speak, after you've done all your education at home and have qualified for the profession in your home country, you are accepted to practice in any given host country in Europe on a temporary basis. So it is recognition of title, and the practice right is exactly the same as the practice right of a local lawyer, which goes very far, which means I, from Frankfurt, doing work in Paris, I can advise not only on German law as my home country law, I can advise, if I decide to do it, also on French law in Paris. I can advise on European law, I can advise on international law, I can advise on any country law. I have the same practice rights as a French lawyer. This directive has been a very, very great success. We can't measure it quantitatively because we don't have travel controls. But I dare to say that literally thousands of lawyers every day in Europe exercise that fundamental freedom of temporary cross-border service. So a very, very great success. Then in 1988, the next step was done. We introduced in Europe a mutual recognition of diploma directive, which says that I, as a German lawyer, I can get my German diploma recognized in France or elsewhere in Europe if I take an aptitude test, which is difficult, admitted, but I do not have to do the full legal education in France or elsewhere in order to become a French lawyer. So I get credit for my home country education. This diploma directive, recognition of diploma directive of 1988, is today part of the recognition of professional qualifications directive, which has broadened the same approach into other professions as well. In terms of numbers, not necessarily important. Not many lawyers have used this, but the spirit behind it is important. Namely, it increases the mobility of lawyers from one country into the other country in order to become a member of the profession in the other country. Then a third directive, and that's the Establishment Directive of 1998. That basically says if you are a lawyer from one country, you may render services in another country with the same practice rights of the lawyers of the other country, not only on a temporary basis, but also by establishing in the other country. So you get full recognition of your home country title in the country of establishment, and you get the same practice rights as a local lawyer in that country. And no bar examen required. You must register with the bar, but there is no examination, there is no aptitude test, nothing. It is an automatic process that you have to go through, simply that the local bar knows you are there. That's the only exercise, the only purpose of that exercise. And the directive has another aspect, and that is, again, aiming at the integration, full integration into the bar of the country of establishment. If you have worked for 3 years on a permanent basis, which means you take your vacations and then you go on working in Paris, but you don't work 3 weeks a year in Paris and then the rest you work in Germany and next year again 3 weeks. So basically you are 3 years in Paris and you work in Paris in French law and community law. You qualify for the acquisition of the French professional title avocat. So without doing an examination, like you would be doing when you do all the French education, or when you go the diploma recognition route, without doing an examination, simply on the basis of 3 years of activity on the spot in local law and European community law, you qualify to become a French avocat, which then means you are not only a German Rechtsanwalt, but you are also a French avocat, and thereby, over the time of 3 years, you have made the entry into the local profession. You are also a local lawyer. And that is very important in terms of visibility. People do not realize that lawyers are crossing borders every day by the thousands. But they realize, look, this is an office of an English law firm or of a French law firm. So they realize that there is cross-border service activity of legal professionals from other countries. And that is very important and is much more important than the fact that the number of establishments of offices from one country to the other is probably relatively low, with a few thousand only. But these are offices that are visible, and therefore the visibility is very, very significant. The directive, the Establishment Directive, says that lawyers establishing in another country may work not only as solo practitioners, they may associate in partnership with local lawyers, they may be employed in local law firms, and they may also employ local lawyers from the other country, provided the other country permits such employment in the first place. So basically, association, which is the most important tool to transfer skills, is permitted under this directive. Now comes a question which is very much on the mind of people in Europe at the moment, and that is, when you come from one country into the other and you engage in cross-border activity, be it temporarily, be it established, which rules govern, which regulatory rules govern your activity? The directives, Service Directive 77, Establishment Directive of 1998, do answer the question in a compromised way. A compromise found at that time. They say, as a matter of principle, the lawyer must comply with both home country regulation and host country regulation. The directive found a compromise on the recognition of title and the practice rights, but they did not find a compromise on the deontology, as we call it. And therefore they said, sorry, we can't solve the problem now. For the moment, you have to live with two sets of rules, home country and host country, which can be burdensome for the lawyers, which is why the CCBE, which is the Council of the Bars and Law Societies of Europe, and we have Marcella Brunbauer, who is the president of the CCBE. She's representing the small figure of 1 million European lawyers right now. Why the CCBE in 1988 has developed a cross-border service activity code for lawyers in order to attempt to alleviate the difficulties from the double deontology. But time is probably ready now in Europe to go one step further, and we are actively dealing now in Europe with this issue. I don't want to go into details on it, but this is something that you must be aware of with the growing cooperation of lawyers from country to country. There comes the day when harmonization is required also in this area. This is basically what I wanted to tell you about the Establishment Directive of 1998. Now there is, which is specifically a lawyer's directive. Now there is another directive that for completeness sake I must mention, and that is the Service Directive of 2006. The lawyer directive, the two ones, are what we call vertical directives or sectoral directives. They address one sector of service only, lawyers. The directive of 2006 is a horizontal directive which applies to all service sectors horizontally. And that service directive of 2006 is aiming at introducing additional facilitation of cross-border activities, not only by other service providers, but in part also for the legal profession. But it is important to say that what has been achieved in the Service Directive for Lawyers and in the Establishment Directive for Lawyers of 1998 remains untouched. So nothing of that has changed, what I've just told you. For you, it is only to remember that additional measures of liberalization are being introduced by this more recent directive of 2006, which is not limited just to lawyers only. What would be my summary analysis of the situation in Europe? Matters have started after 1957 slowly, but it's important to realize that lawyers did cross-border work on a fly-in, fly-out basis, train-in, train-out basis, go to Paris by car or cross the border, that they did that right after the Second War. It was self-understood that within Europe that should be possible, and lawyers did it. And when the treaty came in 1957, the service across border was understood by lawyers to be their fundamental freedom, and they did it. And then gradually over time, liberalization has expanded, and today, as I said earlier on, the European legal profession consists of national professions of lawyers with very much of a European mentality and a European mind. And they share in particular the common core values. And these core values have been recognized in the directives, in all the directives that I have mentioned. So it's important for you to take home when you think of liberalizing, you do not have to be identical on all the details. What you need to share is common core values, and then leave the details for later days. Once you have the common core values, you can really cooperate and you can liberalize legal services across the border. That's an experience that we have gained throughout the discussion in the IBA that we have gained also in Europe. And I think with that positive remark, I would like to conclude my presentation on the experience in Europe. But I don't want to do that without, first of all, thanking you, Mr. Lyubilov, for the idea of this session. Because the session, I think, has proven how useful it is to bring experienced people from many jurisdictions together and share the experience, because that can be helpful for further development. And I think in Akira Kawamura, you found a congenial counterpart coming from two different countries with completely different cultural background, and also difficulties in history way back. It is very comforting to see in today's world how the two of you have cooperated in the preparation of this panel. And that, I think, is very important and comforting for all of us. We are sitting here as lawyers from many different countries of the world, all of which have had their problems in history, but all of which have gathered here in order to help the case of the rule of law and thereby helping the case of peace. And I think with that remark and the expression of my gratitude, Mr. Lyubimov, I would wish to conclude my remarks. And if I may, I would invite you to take the floor now.
Yes, thank you, dear colleague. Ну, дайте по-русски, да, я скажу. Спасибо большое.
Thank you, dear colleague. You know, I have a very good impression of our discussion. I'm present here in two capacities, as a moderator and secondly as an organizer of the event. So for me, it is very important that our forum is not only a platform of social and cultural interaction of lawyers throughout the world, but first of all, it must be a platform of high-quality discussion. It is a second round table that I'm a co-moderator of, and here I see an exceptionally high quality of discussion. So I'm very grateful to the participants of our panel for very interesting ideas, very interesting experience that they have shared with us. And it was my great interest to listen to you. Mr. Halvig started his presentation with remarks about the epoch of Catherine the Great and St. Petersburg of that time. And it is overlapping with the topic of the first roundtable that I was a moderator of. It was in an adjacent room, and it was dedicated to the protection of cultural and architectural values. Well, today an unexpected idea popped up. I suddenly understood how important it is to regulate our life. Regulation is important in whatever sphere of our life we are talking about, be it a regulation of construction and development or providing legal services. Here in the adjacent room you can see an exhibition of photos that demonstrates how lack of regulation, lack of enforcement convert a unique ensemble of the city of St. Petersburg in a set of low-quality architectural buildings, how we are losing the unique ensemble that was developed by our predecessors. Similarly, when we are talking about the regulation of the legal profession, I was very much impressed by the figures of Alexander, the total market figures of legal services that is twice as large as the oil and gas sector, to my mind. So this figure is really very impressive. A lawmaker and a national regulator may give an impetus, speed up the legal services market, or hinder it. So today we have representatives of different countries, and I think that Mr. Halvik and Mr. Gil Taeki have their historical experience of how different types of regulation transform the same economic reality into opposite things. I'm quite a young person, but in due time I visited the German Democratic Republic, and an example of the Western Germany and Eastern Germany indicates very well how the same nation, when provided with different types of regulation, end up in a different result. The same thing is about the Republic of Korea, namely Southern and Northern Koreas. So through different regulations, we receive different results. So when regulating our profession, we must be very cautious and careful not to destroy the market, but rather to provide it with a new development impetus. My co-moderator also mentioned the time of the economic development when foreign trade was only started and everything was about manufacturing. So when talking about the content of regulation, I would like to exercise a different perspective on it. Well-thought regulation and the removal of cross-border barriers is a way to liberalize the market, to grow the market, and to create transnational law corporations. We do know that the largest law firms have turnovers of millions of dollars. These are serious companies with huge labor resources. And trying to make our discussion more topical, I would like to present a different point of view. Is it really good? Is it good that the legal profession that initially was conceived as a very personal profession based on personal qualities in terms of customer and service provider relationship, is it good that this profession is becoming global? What is better, to be serviced by a law firm with 2 partners and 15 employees, or to have a global advisory firm with several hundreds of partners? This is not an idle issue for today's Russian market. I think that the main argument that you will hear from Russian lawyers when you start discussing the liberalization of the market and the balance between protectionism and the openness is that their capacities are not equal to the capacities of global actors in the market. Unfortunately, Alexander has left. I think that he represents a protectionism wing of the Russian legal market. I have heard from partners of many Russian law firms. They think that the competition that they will face in the open Russian market from global players, first of all British and US ones, is actually the same competition that is suffered by organic farmers that produce bio products and have to compete with global food manufacturers who use genetically modified products and ingredients and state-of-the-art biotechnologies.
This is the first question we should pose before ourselves. Must the legal profession be global, in principle, or lawyers, similarly to doctors, hairdressers, I don't know, maybe auditors, bakers, should operate as a business next to your home? And I think this is a very serious issue that we should contemplate. Number two, what I wanted to say with regard to the Russian market. Our situation is very different from what was described by our colleagues here. We have a totally different history of market development compared to Europe, compared to the UK, to Korea, to China, to the US. Those countries that have that are represented by our speakers. The thing is that in the Soviet Union we had a very centralized, over-regulated market of legal services, if it can be called market at all, because it was in reality a community of individual lawyers who could work only on the simplest civil and criminal cases. There was no other requirements. There was no on-demand. There was no businesses. There were no businesses. No large inheritances. So they were involved in divorces, in structuring the simplest kind of transactions, apart from civil and criminal cases. When the economy started to rapidly change, the old core of Soviet lawyers couldn't continue any longer. It started to fall apart, and there was a very interesting point in time when the most active lawyers started to leave Soviet bar associations and started to establish associations of their own. It was equivalent to something like regional bar associations. So in large regions of Russia there could be up to several dozen regional bar associations. In Petersburg we had 15. In Moscow more than 20. Then those bar associations started to fall apart, and when the legislator allowed to provide the services outside the auspices of the bar association, it meant the end to the Soviet legal profession, because the first law firms started to form, foreign companies arrived here, and all the market went there. And the legal profession in Russia today is a shell without any content. It is an organization, the Bar Association, which unites lawyers of the Soviet type, all the commercial market. All those $5 billion that were mentioned by our colleague in his presentation are outside the Bar Association, and in this sense Russia is the most liberal market of legal services in the world. You won't be able to find a single other country where being a vet or metal expert in by training you can set up a legal company, a legal firm, a law firm, and start to operate the next day, and you won't be any different from any other market participant. Your law firm can be founded by a foreign company, an offshore company, anything goes. Our market is totally unregulated. This is a market which has unique qualities compared to anything else you can find on the globe. On the other hand, our bar association also developed, with our bar corporation developed. It was abandoned by the best representatives, unfortunately, but the worst also left. Those who didn't feel comfortable to comply with the requirements of the bar, but the market became free and liberal, they simply left and started to work on the free market of legal services. So in Russia the situation is probably the most paradoxical. We have a free legal market, and we have there the best lawyers, large Russian law firms and foreign law firms, international brands. Even after the crisis, we have several dozen of those in the Russian market, maybe up to 100. At the same time, on the same unregulated market, we have the lowest part of the market. Those are unqualified lawyers, intermediaries in corrupt transactions, lawyers that don't have any understanding about the ethics of our profession. And at the same time, we have still remaining traditional Soviet lawyers that has been preserved in the form of the federal and regional chambers of lawyers. This is a peculiar feature of the Russian market, which poses very difficult tasks in terms of reforming this market and bring it together. Another thing about the Russian market, it is very regionalized. The market of any country that is represented here is very heterogeneous. If you take the UK market of legal services, it's quite clear that London-based lawyers and lawyers from the provinces is not the same thing. But there is no such greater divide between lawyers from capital cities and lawyers from the provinces as in Russia. Moscow lawyers are very different even from lawyers in St. Petersburg. It's a totally different market, totally different scale, different offices, different, talent. These are two different worlds that it is difficult to bring together. Therefore, we are faced with very difficult tasks as real or potential regulators of this market. We need to bring together two lines that departed from one point, but over the 15 years period they have diverged so far apart that you cannot even assess the distance between them. Therefore, today we have several key contradictions that make this reform extremely difficult. The first contradiction is between registered lawyers and free lawyers who are not registered but still operate in the market. Lawyers, of course, want to make all lawyers join their organization. Free lawyers are saying that this organization is obsolete, Soviet-type, ineffective tool, and they don't want to have anything to do with it. That's the first contradiction. Another contradiction is between lawyers in Moscow and regional lawyers. Regional lawyers are concentrated around our traditional bar associations. So if we had to reform only the provinces in Russia, it wouldn't be very difficult. They're only a small part of the market is outside the traditional bar structures. At the same time, we need to bring together all these fragmented bar structures into a single regional organization. The third contradiction, which is probably one of the most serious today, is the contradiction between the Russian national law business, which has grown very significantly. We have about 20 actively operating law firms with an annual turnover of from $5 to $100,000, which is not a bad result for the Russian market. Those law firms, of course, in a fierce competition with international brands. For them, major competitors are UK and US law firms. Traditionally, at the Russian market, we had very strict specialization between Russian law firms and transnational law firms. Russian firms mainly dealt with court cases, administrative and technical advice, and government relations. This is the sphere that foreigners do not usually plunge into. Very few of the international offices worked in those fields, and foreigners traditionally have worked with transactions related to external financing, IPOs, complex transactions in several jurisdictions involving mergers and acquisitions. Now, largest Russian law firms, and they have now about several hundred employees. They are penetrating new segments. They have started to compete with international firms in the transactions segment. This has become especially visible after the crisis. Transnational transactions became went down in numbers, and the Russian law firms, which were more flexible from the point of view of the cost to the result ratio, they found themselves in a more favorable position compared to more expensive foreign firms. And now Russian firms become more and more ambitious, and they are claiming to take back the market that they have lost. Sometimes we're talking not about the struggle for special legislation on the bar association, but the struggle for material law. Russian transactions usually move to UK jurisdiction or some other English-speaking jurisdiction. And in this respect, for Russian lawyers, for Russian law firms, it is vitally important to gradually transition the majority of transactions, big transactions especially, back into the Russian jurisdiction. And many lawyers have told me that it is difficult for them to structure a small local deal in Russian province, I mean a foreign law firm. It is difficult to structure it in accordance with the UK law, with the provision that disputes will be settled in an international, court of arbitration. Because those guys who are 800 kilometers away from Moscow, they are not inclined to read English texts and go to court somewhere in Stockholm. So there is some potential of bringing those transactions back into the domain of the Russian law if Russian commercial and civil legislation improves. Therefore, largest Russian law firms initiated very serious work on the draft of the civil code of Russia, because for them it meant the return of a lot of business back home. So it's very difficult to predict how this controversial market is going to develop in the future. A lot depends on the logic of the reform that will be carried out for the legal profession, and this reform has to be carried out. I think that the Russian regulator is definitely not interested in closing the market down for protectionist purposes. Of course, we would like to establish fair rules of the game for Russians and foreigners who are present in the market. It is no secret that even the largest global law firms working on the Russian market commit certain ethical infringements. So usually, well, yeah, so they provide advice on foreign law using Russian lawyers, for example, who don't have relevant experience. And also, well, there are some other violations as well. But the main task for us as the regulator of the Russian legal services market is to establish civilized rules of the game, and we need also to eradicate those violations that occur in the lower segment of the market. This is a very important problems both for Russian and international law firms. And finally, in conclusion, I would like to say that there is yet another interesting trend that we are observing now. This is a trend towards mergers of large Russian companies with international law firms. Sometimes such mergers occur on an equal basis. Strong Russian companies can even acquire small US, UK and European law firms. This happens as well. So the discussion of protectionism and liberalism in the legal services market will somehow be put an end to by the economic reality. The market that is related to a globalizing economy is going to globalize itself. So our task is probably not to interfere, but rather to create mechanisms that would enable us to convert 5 billion market into 10, 100, 500 billion. I don't know where the limit is. I would like to thank everyone for very interesting discussion, and I would like to pass the floor to my esteemed co-moderator.
Thank you. Thank you, Mr. Yurmov. I think that was a very, very interesting contribution, which I think should be seen before the background of what we listened to this morning. I think it was very important to note that if you want to do liberalization for foreign lawyers coming into your country, you have to do it gradually. Don't do it abruptly, do it gradually. We also learned, and that I think has been the experience, the positive experience in the jurisdictions we've been listened to this morning. We also learned this morning that there is an interface with the situation of the profession at home and how it is being regulated. And so there's an interface with the regulation of the domestic activities of domestic lawyers. And the examples that we've been given this morning, clearly for Korea, South Korea, and for Japan, are examples of countries with a developed and firm national profession. So they were at a stage where they could really open up slowly, gradually, in a controlled fashion. For a country that doesn't really have that level of internal order in its own house, that's a problem. When you said you have lawyers leaving the bar and working freelance and giving legal advice, then of course that is something that is of concern to you, and that I think you ought to bring in order before even thinking of opening up, or at least opening up too much and in an uncontrolled way. There's also an interface with the maturity of your economy. The example that you have given, I think, is very telling, that there are parts of the country that economically have sufficiently matured so that they are ready for the techniques and the complexities of legal transactions. And there are other parts that are not yet so far matured. And I can tell you from my own German experience, and that was eye-opening to me when you compared the two parts of Germany, like you compared the two parts of Korea. When the wall of Berlin came down, it was only a question of months, and there was no legal profession in the East anymore, because they were simply not up to the standards of the West, and that was demanded there, what was demanded there. But there was a similar experience when looking at the economy. The clients in the eastern parts of Germany, they were not yet ready to work with lawyers from the West. And it took a long time to educate the clients in the eastern part of the country so that the two were on a, so to speak, on a level field so that they could communicate with each other. So what is important is also this interface with the maturity of the economy. Very important. And ethics, absolutely. We have a rule in our ethical regulation. It can be an ethical violation if you engage in law activities that you don't understand, that you don't master. That's a serious violation of your duties to the client. But that is not only a specific of foreign lawyers, but it's also a specific of local lawyers. So that is something where, so to speak, national treatment can and should be given to foreign lawyers. But first of all, you have to have national rules in place that ensure, for the sake of the clients, that they are not giving unqualified legal advice. The merger of firms, that's a problem everywhere over the world. We've had it in Germany, we've had it in other countries as well. I think there's one big difference between the legal profession on the one hand and the auditing profession on the other hand. The personal element plays a much greater role, the personality of the individual, a much greater role in the legal profession than in the auditing profession. When you see the mergers of firms, what you need to do is you wait for 3 or 5 years, and then very often it happens that the best and talented people leave because they prefer to work in smaller outfits. So size in itself is not per se a critical criterion. What is important is the way in which the big firm is being run and the ethics that the firm, and I'm speaking as a past managing partner of my firm, the spirit and the ethics that a firm pursues in the way it runs its own affairs, and it makes people, lawyers and non-legal staff, feel at home in the organization. And size in that context is sometimes not helpful, but can work absolutely to the contrary. On the other hand, size can be helpful. Without a minimum size, you cannot do these complicated transactions, and you cannot accompany your clients into other countries. Nor can you assist foreign clients, foreign companies that want to do investment in your country. So it's the difficulty of finding the right balance. There are many aspects that must be considered, and I think that has become particularly clear from your remarks. Rome was not built in one day. So the legal profession in a given country and its structure and order and regulation cannot be built in one day either. It's a process over time. And I think that the session this morning has made a very valuable contribution to that. Thank you once again for you with having the idea and for very, well, thoughtful remarks, provoking also thoughts and reflection on our part that have come to assist in the running of today's meeting. And I hereby declare, if you permit, this meeting closed. Thank you again for having come and for having assisted the meeting so patiently for such a long time. Thank you once again. Many